Telangana State Level Recruitment Board. Agreed by the orders passed in writ petition number 185/48 of 2023 and batch dated 9th October 2023 and writ appeal number 1107 of 2023 and writ appeal number 1119 of 2023 and writ appeal number 1137 of 2023 are filed by the petitioners as filed by the writ petitioners, contending that some more questions were to be deleted from the scheme of examination as some of the questions on the ground that the questions were capable of yielding to multiple answers and there is no correct answer being provided to certain questions. Third, EP for services 1 for the appellants. And unnara sir, senior principal unnara. Ramakant M. Ramakant Reddy, K. Ramakant Reddy for the appellants. Appearing for what answer? Appearing for Telangana State Level Police Recruitment Board and GP for services for state government and Senior Counsel G. Vidyasagar appearing for the appellants in writ appeal number 1107 of 2023 and writ appeal number 1119 of 2023 and Vladimir Khatun, counsel for the appellate is 1137 of 2023 and N.S. Arjun Kumar and Ramesh Chilla for the respondents in the writ appeal filed by the state. It has been contended by the appellant state as well as state level police recruitment board that they have issued a notification to fill up Riflery Cadet, Police Constable, Civil and other categories on 13/4/2023. In all, how many posts are notified, sir? In all, 15,644 posts were notified. And what else? Look at the book, list of dates and picture. Right. And the selection comprised of preliminary test followed up by final examination. That consisted of preliminary examination followed up by physical efficiency test and final examination. And the appellants have conducted appellant board has conducted the examination, final examination on 13/4/2023. And the final written examination consisted of objective type questions having 4 multiple options of answers, and a candidate has to mark only the nearest appropriate answer to any of the questions. The appellate board has published the preliminary key on 22/5/2023 and invited objections to the questions which had appeared in the final examination. Several candidates have filed their objections with regard to correctness of the question and also to the correctness of the preliminary key. And the appellate board has referred all these objections to an expert committee consisting of body of academicians, and after obtaining their opinion has published the final key on 30/5/2023. And some of the respondent have some of the respondent candidates who were unsuccessful, who have appeared for the final examination, has filed writ petitions, that is writ petition number 187/46 of 23 and batch of cases before this honorable court, challenging the correctness of questions as well as answers provided to the questions. And a learned single judge of this honorable court has partly allowed the writ petitions by directing to delete question number 122, 130, and 144 and question number 57 without appreciating any of the contentions raised with the. Let's see.
57 of booklet C.
All these are pertaining to booklet C only. These 4 questions. Question number 122, 130, 144, and question number 57 of booklet C, and directed the appellant board to redo the exercise by deleting the marks awarded to the candidates afresh without appreciating any of the contentions raised by the appellant board. The counsel for the appellant board has contended that in paras 50 of the judgment of the learned single judge, the single judge has come to a conclusion that courts cannot go into the correctness or otherwise of the answers in the final key to the questions prepared by the board, as the final key was published only after the expert body / committee has looked into the objections received from various candidates. When the learned single judge has come to such a conclusion, the learned single judge could not have deleted 4 questions from the scheme of examination and could not have directed the appellant board to redo the exercise afresh by deleting 4 questions, which runs contrary to the finding recorded by the learned single judge in the preceding paragraph. The counsel for the appellant board had further contended that all the objections were referred to a body of expert committee, and only after expert body giving its opinion only the final key was published. Therefore, the learned single judge was not justified in interfering with the questions, and the learned single judge could not have directed to delete 4 questions from the scheme of examination. The counsel for the appellate board had contended that the learned single judge has set aside 3 questions on the count that the answers in Telugu version were not properly translated in Telugu, whereas whereas the expert body committee has come to a conclusion by nearly not translating the key answers in Telugu would not change the nature of the question. As per instructions to the candidates, issued at the time of examination, it was made very clear. Instruction number 9 of the instruction number 9 would make it very clear that the question paper booklet will be printed in two languages, English/Telugu or English or Urdu. In case of any doubt or ambiguity in any question, then the English version is to be considered as the correct version. Admittedly, there was no error in the English version. The only issue raised by the respondent candidates was that the answers were not properly translated in the Telugu vernacular language, except writing the English word in the Telugu. That itself would not make the question as invalid. As the instruction number 9 to the candidates has made it very clear that the only English version of the questions have to be taken into account for finality. But the learned single judge has allowed the repetitions and directed to delete 3 questions on the ground of not properly translating the answers in Telugu. The counsel for the apparent board has further contended that in respect of question number 57 of booklet C, the answer was recorded as Pradeep instead of Paradeep Port. Since Paradeep is a noun, it can be pronounced in a different way also. That alone cannot be a ground to delete question number 57 from the scheme of examination. The counsel for the appellate board as well as EP for state has contended that the issue was clearly covered by judgment rendered by the Honorable Supreme Court in Ran Vijay Singh versus Uttar Pradesh, State of Uttar Pradesh, reported in 2018, 2 SCC, page 357, wherein the Honorable Supreme Court held that if there is any dispute with regard to answers, then the benefit of doubt should go to the examination authority, but rather than to the candidate. The counsel for the appellate board had further contended that the burden of proving that the answers furnished in the final key are demonstrably wrong by the candidates, and burden lies on the candidate. Nowhere in the writ affidavit nor any contention was raised that the answer provided in the final key was demonstrably wrong, except saying that the answers were not properly translated in Telugu. That can't be a ground to set aside the questions from the scheme of examination. The counsel for the appellate board has further relied upon a judgment of Honorable Supreme Court in Vikesh Kumar Gupta versus State of Rajasthan, reported in 2021 2 SCC, page number 309, and held that what should be very slow in interfering with the correctness of the questions. More so, the answers were finalized after taking opinion from the subject opinion. Therefore, learned single judge was not justified in interfering with the questions in the examination, and the learned single judge ought not to have directed the appellate board to delete 4 questions from the scheme of examination. Therefore, appropriate orders be passed in the writ appeal. By setting aside the orders passed by the learned single judge, single judge and allow the writ appeals. The counsel for the appellant board and further contended it because of the orders passed to the learned single judge. 15,644 vacancies could not be finalized, and the final results were already published by the appellant board on 4/10/2023. Because of pendency of the cases and the present writ appeal, the recruitment process is being delayed. Therefore, appropriate orders be passed in the writ appeal by setting aside orders passed by the learned single judge and allow the writ appeals. The counsels appearing for the respondents and appellants in writ appeal number 1107 of 2023, 1119 of 2023, 1137 of 2023 had contended that in all there are nearly another 9 questions which were not considered by the learned single judge, and to strengthen their argument, they have argued that each of the disputed questions is defective, and those questions are capable of yielding multiple answers. Therefore, the final key which was prepared is contrary to the certified textbooks of intermediate standard, and to that extent, the counsel for the appellant has relied upon छोटा इसको मैं लिख लिया करने difference एक writing है एक separate total no serious argument. దీనికన్నా రాసిన इतने रिलेटिव people got 9. ओपन वार्निंग दिए थे मैम ये दूसरा डुप्लीकेट दीजिए उसमें लिखिए
इसको ऊपर देखना है मेन बंडल के ऊपर yesterday 2-3 bundles are picked up from the sets.
Yes, madam.
Tell me that.
107
Madam, 1107.
and the first part.
First.
Last document, contact council document. 37. 11, maybe 11, last.
Last.
Last was.
11:37 देखिए. Yes, this is okay. Thank you. This makes everything. Right.
Therefore, finally, key which was prepared contrary to the certain textbook that is intermediate standard, and to that extent, the land council for the appellant
Correct.
has relied upon.
As you demonstrated that question number 75, 94, 102, question number 21 and 47. And to demonstrate that these questions are contrary to the answers furnished in the textbooks. You said 75, 94,
99, 102, 117, 126.
Mine is 21 and one shop.
Azasarama. You said 75, 94,
99,
99, 102,
117,
117, 126 and 175. And 21 from first year.
21 and 142.
21, 75, 94, 99, 102, 117, 147,
126.
126, 147, then 175, correct? And contended that the run single digit ought to have also dealt in respect of these questions as admittedly the appellant /respondent could demonstrate before the single judge with authority that the answers furnished in the final key are contrary to the prescribed textbooks for intermediate course. The counsel for the appellant candidates had contended that since the answers are capable of yielding multiple answers, and that is the reason the appellant candidates could not answer those questions properly, and that has caused a great injustice to the appellant candidate. Therefore, praise that this honorable court may also deal with the questions which are referred in these appeals and delete those questions on the theme of examination so as to ensure that justice is done to all the candidates. For the mistake committed by the respondent board, the meritorious candidate should not suffer. Therefore, appropriate orders be passed in the appeals referred by the candidates by deleting the questions such as question number 21, 75, 94, 99, 102, 126, 147 and 175. And thereafterwards direct the respondent board to finalize the selections, as admittedly the meritorious candidates would be put to sufferance. Any other argument, sir? The counsel for the appellant's candidates had relied upon a judgment rendered by the Honorable Supreme Court in Vaishta Tabassum versus National Testing Agency and held that the disputed question should be referred to expert body plus to refer to independent expert body and let the independent expert body consider all the disputed questions so that there is transparency and confidence means and the confidence in the unemployed youth will be installed. Huh? Otherwise, the entire recruitment process would be completed with incorrect key answers. The counsel for the appellant candidates had also relied upon a judgment rendered by the Honorable Supreme Court in Vikesh Kumar Gupta and another versus State of Rajasthan, wherein
Vishal, I also relied on Vishal.
Huh?
Vishal. Page 17.
page 17 relied upon a judgment of the Honorable Supreme Court in Rishal and others versus Rajasthan Public Service Commission, reported in 2018, 8 SCC, page 81, wherein the Honorable Supreme Court has in fact directed that the final key along with the expert opinion should be furnished to the candidates in order to have a transparency in the recruitment process. No prejudice would be caused if the disputed questions are referred to independent body of experts, as admittedly the expert body was appointed by the appellant board and the expert body which is appointed by the appellant board will not disagree with the preliminary key prepared by the appellant board. Therefore, in order to have a transparency in the entire examination process, let the disputed questions be referred to an independent body of experts, and that exercise can be done by the appellant board within a period of 2 weeks, and later the selections can be finalized depending upon the expert body's opinion.
They also not confined to the candidate, para 27, page 49. Report that you cannot be confined only to candidates. It should be
The counsel for the appellant candidate had contended it. The appellant candidates are not contending that the benefit should be extended only to the appellant candidates, but to the entire persons who have appeared for the examination. In order to have a transparency in the system, in the interest of justice, let the disputed questions be referred to independent body of experts, and thereafterwards let the selection be finalized depending upon the opinion of independent body of experts. This court having considered.
not referred to my contention, referred to the, because it's a different appeal. Argued as a different.
Correct. Counsel appearing for the respondent board had contended that when once the disputed questions along with the objections were referred to body of experts, the question of referring to again body of experts would not arise. Maybe this is called a submission.
Way to demonstrate if this.
Correct. This is called contention. The counsel for the respondent board had further contended that when the appellant candidates have not demonstrated before the court as to how these questions are incorrect, then and in the absence of same, the question of referring these questions to again to the expert body would not arise. Therefore, there are no merits.
My further submission, but all the petitioners have never raised any objection.
Correct, right. The counsel for the respondent board had further contended that none of the appellants and the writ petitioners who have approached this court have not raised any objections to any of these questions when opportunity was given to the writ petitioners, appellants, candidates to file objections. When they have not filed any objections, the question of entertaining the writ petition at the instance of those candidates would not arise. Therefore, referring the disputed questions to another expert body of academicians is not warranted, as the final key was published only based upon an expert body opinion. The question of referring once again would not arise. Therefore, there are no merits. Writ appeal is liable to be dismissed.
There are 14 of this litigation.
The counsel for the respondent board had contended that the issue was considered by the Honorable Supreme Court in Vikesh Kumar Gupta versus State of Rajasthan, reported in 2021 2 SCC page 309, wherein the Honorable Supreme Court held that a division bench was not, it is not open for the division bench to examine the correctness of the.
But opinion must be
16 కదండి.
there are 14.
Okay.
Show difference and consideration to the recommendation of the expert committee. The bad expert is division.
Held that it is not permissible for High Court to examine the question papers and answer sheets, particularly when the Commission has assessed the intent and merit of the candidates. Courts have to show difference and consideration to the recommendation of expert body who have the expertise to evaluate and make recommendations. In the instant case, disputed questions were referred to expert body along with the objections, and expert body has opined and finalized the final key. The question of referring once again to the independent body would not arise. Therefore, there are no merits. Writ appeal is liable to be dismissed. అది చెప్పాను కదా మీ అప్పీల్లో
It's like you know, I am relying on para 30.3, 30.4 and 30.
సేమ్ ఆర్గ్యుమెంట్ ఉంటుంది కదా, మీరు అప్పీల్లో అప్పీల్ చేసిందే కదా.
So this 30.4 and 30.5 maybe. Court should presume the correctness of key answers in proceed of the assumption and in the event of doubt, there is rather than
The counsel for the appellant board has further vehemently contended the issue was considered in Ran Vijay Singh versus State of Uttar Pradesh, reported in 2018 2 SCC page 357, and the Honorable Supreme Court held that
Para number?
being on 30.4 and 30.5.
the court should presume the correctness of the key answers and proceed on that assumption. And even if there is a doubt, the benefit should go to the examination authority rather than to the candidate. Admittedly, if there is any benefit of doubt, it should be given to the recruitment authority, but not to the candidates. And the learned single judge could not have deleted the questions only on the presumption that only on the presumption that the questions are not properly translated and one of the answer is improperly spelled. Therefore, there are no merits. All these writ appeals filed by the appellant candidates are liable to be dismissed, and the writ appeals filed by the recruitment board are liable to be allowed. Any other contentions or anybody? ఇంకేమైనా చెప్తారా?
It's something raised.
You have not filed an appeal. How can you argue?
No, but they counter it. The counter is 130, there was some are raised.
Huh?
There are applications. How many percentage of candidates have?
No, no. You have not raised. Yes, furnish one details. None of the petitioners.
Counter in the, before the land single, that is not overall objections of candidates.
There is overall objections, not petitioners.
They never said the petitioners have not said, they said these are all the objections. They go on instructions, we not have given 19/12/2000, the appeal we on 19/12, dated 19.
Yes, yes.
This court called for instruction, we not have submitted, all the
Yes.
candidates given instructions were not.
Okay, this court having considered the rival submissions made by the party, considered it. The learned single judge was not justified in deleting the 4 questions on the ground that the answers to the questions were not properly translated in Telugu. And the learned single judge finding in para 17 would make it clear. 16, 15, make it clear that the learned single judge has come to a conclusion that the key answers cannot be interfered. As the final key was finalized by the body of experts, and the learned single judge declined to interfere in respect of certain questions, but very strangely, the next preceding paragraph, the learned single judge has set aside 4 questions on the ground that 3 questions were not properly translated. The key answers were not properly translated in Telugu, and in respect of 1 question, it was set aside on the ground that it was not properly spelled. Therefore, the orders passed by the learned single judge in directing the appellant board to delete 4 questions from the scheme of examination and finalize the selection is contrary to law. Accordingly, the same is set aside. The court should be very slow in adjudicating the matters, more so when team of experts have held that the questions were properly framed. But in order to install confidence in the unemployed youth, and when questions are being doubted by the candidates in the form of objections, this court is of the considered view. In order to resolve the entire issue once for all, this court deems fit to refer all the disputed questions to a body of independent experts and finalize the selections after duly taking second opinion from the independent body of experts. And this would cause no prejudice to the appellant board nor to the candidates, and it would clear the minds of unemployed youth, and it will instill great confidence in the recruiting agency itself. Therefore, this court is of the considered view. And for the reasons stated above, this court directs the appellant board to refer the disputed questions to a body of experts, an independent body of experts to be constituted by Usmania University, and the appellant board would ensure that the same body of experts who were forming part of earlier expert may not be the same persons, and we expect this exercise to be done by the appellant board within a period of.
What depends on the university.
The instruction is put so that we'll 2 weeks I think they can't do it.
Should be limited to that because they are also anxious to get it complete.
Okay.
Upper limit will have to be put it for 4 weeks.
Emrah,
Disputed questions to be constituted by the Usman University and the appellant board.
Actually, refer to the specific number of questions because the emanating person.
correct.
Into these questions.
Yeah. Emrah.
Same persons may not be same persons and who are
Now we also if it's being filed.
this exercise can be done.
Questions again. They may say that our case should also be different.
Emrah, sir.
This exercise should be done by the appellant board within a period of
As expeditiously as possible, preferably within a period of 2 months.
Just 2 months, 4 weeks.
Outer limit is 2 months.
4 because they can meet in 4 weeks also.
Okay, within a period of 4 weeks. And finalize the selections as expeditiously as possible. There.
One should be direct the constitution refers to question number so and so. Specifically said. Because only those questions are.
Disputed questions referred in the present case.
In the numbers.
Okay. Disputed questions such as question number 21, 57, 99, 100.
So these translated questions will not, the question may not refer it because they have shown judgment. Questions also. No, they have demonstrated because the courts by judgment, you are not saying that. Pradeep does because question number 57, Pradeep is not an independent question, it's not the following. By inference, we are it's only Pradeep is there. There is no other Pradeep or Pradeep. The observation of the signal change is being deleted, saying that it should not be deleted. Not have been deleted. Our entire argument is that they cannot be deleted, they cannot be. By sending that phone also. No, merely because when you are demonstrated by judgments, in support by judgments and also books will not.
Tamil Nadu judgment pension.
No, I've shown sixth class science book, you're not showing it.
No, there's a Tamil Nadu judgment pension. Yes, he is right, sir. Tamil Nadu has considered this issue. And respect of.
That again came up for consideration before the Delhi High Court also said that not spelling mistake cannot be deleted. I refer to the judgment which I filed.
Sir, 1 minute.
That cannot be because not only it's not only the only I mean this one other covers to please put refer they are considered to refer that question only. Page 9 of my paper. Percentage is virtually see what is the binding. Page 9.